and I'm here with Tim Markle and Julie Hajewski. We work with the Wisconsin Youth Health Transition Initiative. You should have all received an agenda prior to the call. First, a few reminders. During the call, please mute your line so that any background noise and conversations will not become part of this archived presentation and be potentially distracting. You can control this in the Zoom conference room using the mute feature located in the lower left corner of the window. We will reserve time at the end of the presentation for questions and comments. Please unmute yourself when you want to talk. We will monitor the chat box throughout the presentation, so if you prefer, please type your questions into the Zoom chat box. The presenters will do their best to address all the questions at the end of the presentation. To help us track attendance, please put your name and organization in the chat box so everyone knows who is here. If you're not able to connect by computer, please email your name and organization to guthriemoss@wisc.edu. That's GUTHRIEMOSS@WISC.edu. A recording of this presentation and accompanying materials will be available at a later date on the Health Transition website under the Learning Community tab. At the end of the call today, please complete the evaluation at the link provided in the chat box. If you must leave the call early, please take the time to fill out the evaluation before logging off. Please provide possible topics for future Learning Community calls so that we can continue to offer interesting presentations and quality content to our healthcare transition champions like you. Today, we will hear from Kristen Crabtree. Kristen recently graduated with a doctorate in nursing practice with a focus in pediatrics from the University of Wisconsin-Madison. She's also a Wisconsin Land graduate. Kristen will provide information on how health professionals can use the process of supported decision-making in their practice for youth with special health care needs to encourage independence in decision-making. Attorney George Zaske will join Kristen as her guest to provide a legal as well as parent perspective. So if you're interested in scheduling a presentation for your clinic or organization, please email Beth Guthrie Moss at guthriemoss@wisc.edu, GUTHRIEMOSS@WISC.edu. Okay, let's go ahead and get started.
Right, 1 second here. There we go. So hi everyone, as Beth just mentioned, my name's Kristen. I'm excited to be here with you all today, even though I wish we could be in person, but that's okay. So as you all know, we're going to talk about supported decision making. Next slide. So as Beth said, my name's Kristen, and I recently graduated from UW-Madison with a doctorate of nursing practice and a focus in pediatric primary care. Throughout the past few months, I've been working with the Youth Health Transition Initiative, specifically focusing on supported decision-making as part of my practicum through the LIND program. I would like to welcome our other presenter today, George Zaske. He is a parent of an adult son with a cognitive disability and also a solo attorney with a practice that includes family law, estate planning, guardianship, and elder law. He is also a disability policy advocate, and we're very excited to have him here today to learn from his perspective. Next slide. So I personally have no disclosures to share. George does want to disclose that he's here to educate and provoke thoughtful discussion. He is not here to give legal advice that should be relied upon, as he does not know your specific facts or your circumstance. Next slide. Before getting started, I would like to acknowledge a few people, starting with the Wisconsin Board for People with Developmental Disabilities. Their resources have been a really major part of me learning about supported decision-making, and they have put a lot of work into their resources, and I highly recommend them as a resource for all of you to learn more about supported decision-making. I would also like to acknowledge Julie Hajewski, Ann Harris, and Beth Moss for all of their support in making this presentation and all of their feedback. Next slide. So to start us off, George is going to share his experience with supported decision-making, and then we'll start with the rest of the presentation with objectives, followed by our supported decision-making content. So take it away, George.
Okay, thank you, Kristen. Thank you for having me. I've been involved in supported decision-making for a great number of years. Before even the law, I was also involved in the group that drafted the law that we have in Wisconsin here. And the impetus for that is for the young man you see on the slide in front of you. I did get his permission to show this picture. He has his own person. We try as his parents, my wife and I, to include him and ask his permission when we share stories about him, that he recognizes that if we are going to move this world forward for people with disabilities, that some of us, including him, have to be willing to get out there and share our stories. And one of the things about Franklin, he's very sports oriented. He loves basketball, and that's one of his prides and joys. And this picture represents that. And right now we're going through some challenging times because the basketball season for Special Olympics was cut short because of the COVID pandemic. And we're trying to, figure out ways to get outside and get some more exercise and encourage him to use the basketball hoop in the driveway. A number of years ago, I went to a presentation by Jonathan Martinez, and he talked about the concept of supported decision-making and to use that instead of guardianship. And I was intrigued by that concept and have followed that concept of supported decision-making ever since. And when my son, who's in his early 20s now, was getting ready to turn 18, we had to figure out as a family whether or not we were going to go forward with guardianship. And there is a tremendous amount of systemic encouragement, this word I'll use, for going for guardianship. Our system is very much geared for that. It's a way of a parent always having access into either a financial meeting, an IEP, or even healthcare. But Franklin has a rare form of epilepsy, and for that reason, I've been very interested in following neuroscience and neuroscience research, And what we found is that with the brain, and talking to medical people, maybe I'm certainly out of my depth here, and you probably know more about this subject than I do, but the brain physically does not fully develop until about age 24, age 25. And what the research has shown is that if you, in a sense, restrict or cut off young people's ability to make decisions, to make mistakes, to try and grow and mature, physically it doesn't happen. The neural pathways are still developing. The ones that are favorable, they get strengthened. The ones that don't need to be utilized as much can fall away. But what research has shown, when a guardianship is put on a person, they in fact stop developing. They realize somebody else is making decisions for them. But the systems are set up very much for getting a guardianship because there's the notion of being able to help that person and protect that person because they're vulnerable. But knowing that about cognitive development, I think back in my own life, and I'm willing to admit I made decisions when I was 18, 19, 20. I was legally able to do that, but more than once my parents looked at me with their head tilted to the side and a furrowed brow. And I think most people would, if they're honest with themselves, maybe not publicly admit that, but certainly would admit that. And that's there. When some students, they can go under IDEA to school till age 21, but oftentimes folks like my son, for example, he had no interest in going on to school beyond his graduating class. And so for many students, if they take that approach, if they have cognitive disability, is their learning in a sense stops. And if their parents get guardianship, oftentimes the decision making switches to them, and in their best intention are trying to keep their child safe. And I've done guardianships, and people are under a misconception that you can protect your loved one with a guardianship. Actually, research shows that the more autonomy and more independence an individual with a disability has, a cognitive disability has, that they can start to understand boundaries and protect themselves better over time. And the other thing I like to tell parents is if you do get guardianship, you're going to be passing that on to somebody else. But knowing about supported decision making, the concepts, like the idea, but the pressure really grew. I will admit that we went partway down that path to getting a guardianship, and turned out that that was not the right path for us to go. And so we decided to stop that. I had already filled out a lot of the paperwork. As you might imagine, as an attorney, I could do all of that stuff myself. But when we got into the process and saw some of the effects on our son in terms of his mood, what it is that that could be said about him, that he was going to be publicly declared incompetent, we just couldn't go that route. So we decided to use supported decision making as a way of allowing him to grow, to provide support for him to make a decision. That's the thing about supported decision making. It's to support someone making a decision. Guardianship and even powers of attorney are substitute decision making options. And that's where somebody else substitutes their judgment. So we didn't want to necessarily go down that route. So the law was not in place at that time, but because I am an attorney, I can draft releases, I can draft powers of attorney, I can work with my son to be able to navigate some of the systems. And that's what we had to prepare to do. On his 18th birthday, before we got cake, we went to a notary and had him sign off on a number of documents that we had talked about prior to his 18th birthday. And that way everything was in place for us to be able to, talk with his dentist, talk with the medical providers, talk with the bank. And we were going to use this supported decision-making concept with him and allow him to make a lot more of his decisions, and not supersede that by just being his guardians. One of the things that we found out going through this process is a lot of the systems are not designed for supported decision-making. So we would run into some issues against these big systems, and as an attorney, I knew that they couldn't legally enforce some of what they were enforcing with their rules, but I'm one parent, one person, and it's hard to push against large financial institutions that are, national banks, large healthcare companies, associations. So it's important to have some way of pushing back. And so there was a group that got together to draft the supported decision-making law, which is chapter 52. And one of the things that we hoped with this law is that more people would embrace this concept, because supported decision-making as a concept, I find as a lawyer, having a law or a thing, if you will, is more tangible and easier to wrap your head around than conceptually saying, oh, I'm doing supported decision-making. Well, my definition of supported decision-making may be different than somebody else's. But at least now with a law, we can take a look at, this is the way we've defined it here in Wisconsin. And so we've used this process with my son, and I can tell you over the last number of years, the growth in his maturity and what he's doing has been tremendous. I mean, right now he is employed in the community as an essential worker, making more than minimum wage. At 17 and a half, I can tell you he was not, jumping up and down, being willing to go out and work. The idea of sitting home after high school and playing video games all day was very appealing to him. But I can say now, after he's been through some Project Search and some other training programs, he really enjoys going to work, and he enjoys having his own money. And we continue to build on his skills, and he continues to improve in his decision making. I will also say guardianship may be appropriate at some point in time for him, but I can tell you it will be a limited guardianship. We're still learning. And that's the other thing about this window of 7 years. It gives you a chance to really understand your loved one and see how much more growth they have. Because if you just stop it at 18, you really limit, in my mind, the amount of development that can happen. So that's been our experience. That's my son, and I'm as I said, I'm happy to educate and participate in this presentation.
All right, Tim, I think we can go to the next slide. So thank you so much, George. I really appreciate your story and your insight and Franklin's story. And I think we're all thankful for you sharing it. And most of the themes that you talked about in your story will come up throughout the rest of this presentation. So it really is a good kickoff for our content. So let's see. Like I said, I think the story will be a great reference point for us as we get into the content of distinguishing the difference between shared decision-making and supported decision-making, discuss other available transition tools such as guardianship and some of their implications. We'll also be looking at different scenarios in which supported decision-making may be appropriate, and further discuss the healthcare provider's role in supported decision-making, in addition to beneficial tools that can be accessed in practice. Another thing that George will be touching on later in the presentation is some considerations from the supported decision-making state statute, and his perspective as an attorney and as a parent will be really helpful with that content. Next slide. All right, so as healthcare professionals, I'm sure we've all heard of shared decision-making. And so when first learning about supported decision-making, this was something that was very confusing to me, because as I was going to say supported decision-making, all I would say was shared decision-making, because that's what I've known since I've entered healthcare. So I think it's important for us to distinguish the difference between the two and just acknowledge that shared decision-making is something that we probably all practice, and it is different than supported decision-making. So shared decision-making is the model of care, and we use it on all people to promote individuals to be engaged and informed to make the best healthcare decisions. And so it really is the idea of, partnering with patients. Supported decision-making is a little different in that it's an actual legal process, and there's a supported decision-making agreement that's created that is necessary to implement the process. It also defines that people who are eligible need to be adults who are at least 18 years of age and also have a functional impairment. The terminology functional impairment is what's used in the state statute, and we'll define that a little bit further later in the presentation. It's also important to acknowledge that in order for supported decision-making to be implemented, the agreement needs to be signed with the supporters of the adult with functional impairments choosing. I also do want to just identify that I may say shared decision-making and just know I most likely mean supported decision-making, so I apologize if that happens. And I also wanted to establish SDM as the acronym that will be used in this presentation for supported decision-making. So if you see SDM from here on, it is referring to supported decision-making, not shared decision-making. Next slide. So before we dive into the specifics of supported decision-making, I do want to touch on some other important tools that I'm sure we've all seen in practice and that can be used to assist adults with functional impairments in making decisions. So these are kind of the old players in the game. Like I've said, I'm sure we've all seen them and recommended them in practice. The first is a release form, which is a minimally restrictive on an individual's rights in a way that an individual can authorize access to medical records for people that they identify as they want access. It can be useful to augment a supported decision-making agreement so that the identified supporters can get the information they need to assist the adult in making informed decisions about their healthcare. I think it's important to say once again that in order for the supporter who is in the signed agreement with the adult with a functional impairment to access the medical records, they do need a release form, and that the adult as an autonomous individual can still access healthcare records without a supporter. The second tool I just wanted to briefly touch on is the power of attorney for healthcare, which is a legal document, and once again, I'm sure we've all seen it in practice. Healthcare power of attorneys are appropriate for situations in which an individual is not able to make decisions for themselves, and the specific authority granted when and for how long is outlined in the power of attorney agreement. The last decision-making tool I wanted to touch on is guardianship. And as George mentioned, it can be limited or full. And I'm sure we've all seen or maybe even recommended guardianship in our own practices. I think it's important to just identify that guardianship is the transfer of decision-making power to a court-appointed guardian. Emphasis on the word transfer of decision-making power. So it can be very restrictive on an adult's decision-making rights. So now let's go to the next slide. So I did want to touch on the implications of guardianship, and I think George kind of already did that and did a great job of bringing in his perspective and his story with his son, Franklin. Some of the things to consider when thinking about guardianship are the idea that the individual is deemed incompetent, and that can be very painful to individuals with disabilities due to focusing on incapacity as opposed to their strengths. This can contribute to a loss of dignity and feelings of a loss of respect. Individuals who are deemed incompetent can also lose basic day-to-day rights that they are capable of, which could lead to a loss of self-confidence and feelings of incapability. This can hinder their opportunity to learn, to make mistakes, and develop decision-making skills. It's also important to consider that the appointment of a guardianship may lead to assumptions from people in society that the individual they're speaking to is totally incapacitated, and people may view that individual as less capable than they actually are. As George also mentioned, there is a greater risk of abuse and exploitation by others whenever you're transferring the decision-making rights of an individual to a court-appointed guardian. Next slide. So I just wanted to take a little bit of time here to allow us to reflect and hear a little bit from you guys. So go back one, Tim. Thank you. And so now we're going to take a poll, and I'm just wondering, in your role as healthcare professionals, can you think of a situation in which guardianship may not have been the best tool for a patient? So we'll just give about 10 more seconds here for anyone else to respond. All right, so looking at it, it looks like a little over half of people have responded, and 93% said that they can think of a situation in which guardianship was not necessarily the best tool for the patient. And so 93% is a pretty high number, and I think that speaks to how much we get stuck into our status quo in systems like healthcare and education, and that even though it's the status quo and it's our normal, it doesn't necessarily mean it's the right thing to do. So let's go to the next slide, Tim. All right, so now I just want to transition into focusing on supported decision-making. And I did just want to kind of reiterate that it is a comprehensive legal process. Even though it's comprehensive, today we're focusing on supported decision-making and how it can be used in healthcare. I think it's important to recognize that supported decision-making does enable individuals to make important life decisions instead of having someone appointed to make decisions for them. And some of those important life decisions can include where and with whom they want to live, where they want to work, what services and supports they want, and also what medical care that they want to seek. Next slide. So as part of creating this presentation, I did interview a nurse practitioner who works in mental health in the Gunderson Health System. And I just wanted to learn a little bit more about how she sees supported decision-making in practice and learn a little bit more about any takeaways that she's gotten from using supported decision-making in practice to share with all of you. So the first takeaway I want to share is that many patients have a fixed belief that their medical provider should be telling them what to do, and they tend to wait for that direction. Supported decision-making helps to include the patient in the process and make them a more invested part of their healthcare. So I think that's a good way to just keep in mind that as professionals, people do look to us for answers, but it is important to practice supported decision-making, shared decision-making, and really engage patients as partners in healthcare. Next slide. So earlier, I mentioned that we would talk about who's eligible for supported decision-making a little bit more. And so like we said, adults who are 18 years or older who have a functional impairment are eligible for a supported decision-making agreement. A functional impairment is defined by the state statute as a physical, developmental, or mental condition resulting in major life limitations. And some of those limitations include independent living capacity, self-direction, self-care, mobility, communication, or learning. And as we move forward, I do just want to say that when considering patients for which supported decision-making is appropriate, we really should be considering the situation and the circumstance and the limitation instead of the diagnosis for which they've received. Next slide. So just to put a face to the name, we did want to share a few scenarios in which supported decision-making may be appropriate. So the first one is Joey, who is an adult that communicates non-verbally. He often feels as though he isn't involved in appointments due to miscommunication. A supported decision-making agreement may be appropriate for Joey to make sure the healthcare professional understands his needs. Next slide. And so our second scenario is Jill, who is an adult with medical complexity that has frequent interactions with the healthcare system and gets an overwhelming number of recommendations. She's often told she needs to have another surgery or try a new treatment regimen. For Jill, supported decision-making could assist her in making informed decisions by better understanding the whole picture, including the risks and benefits. I did just want to touch a little bit on Jill's scenario of, as healthcare professionals, we try our best to give all of the information to allow people to weigh the risks and benefits to make the best decision. However, in some situations, patients are overwhelmed with so much information and healthcare is limited by time. And so by having a supported decision-making agreement for individuals with medical complexity, it can help them really take that time and have someone that they trust to go through and really weigh the risks and benefits before making a decision. Next slide. So now that we've introduced supported decision-making, I do want to talk a little bit about the health professional's role, and this will focus on assessment of decision-making capacity, and then we'll touch a little bit on providing appropriate recommendation. Next slide. As health professionals, we all know that gathering an accurate assessment is really important to guide our recommendation and then our treatment plans. So when considering recommendations for people who may be eligible for a supported decision-making agreement, and when assessing their capacity to make decisions, we really need to assume that the adult can make decisions. I think it's important to be aware of our implicit biases that we all have when looking at an individual so that we can be self-aware and we can recognize if we're just making automatic thoughts that, oh, there's no way that this person can make a decision for themselves or live autonomously because we haven't even gathered enough assessment information to make that judgment. So being self-aware and recognizing our implicit biases are really important from the start. It's also important to remember to talk directly to the client. I think that this can be hard. I know, especially in pediatrics, when assessing kids, they have a caregiver who can sometimes be the one who wants to answer all of the questions. And I think naturally over time, as kids become adolescents, caregivers back off a little bit and try to give some of that decision-making power to the adolescent. However, sometimes that doesn't happen, and I have seen it quite a bit with adolescents with functional impairments who have a caregiver who has really taken that role of decision maker. And so you're talking to the caregiver, not talking to the individual. And if you're not talking to the individual, then it's impossible to make an assessment of their decision-making capacity. I think another thing that's important to consider when assessing decision-making is what supports are in place. So have they been working on developing the skill of decision-making, or do they have a caregiver who's really taken that role and has made decisions for this individual their entire lives? Have they started any sort of forms like release forms or signed a POA? What sort of supports have they already put in place to successfully transition regarding decision making? And then what do they know about the tools? Have they heard of supported decision making? Has anyone taken the time to really present all of their options and discuss them to help the adult make an informed decision about what tool is appropriate for them? So all important things to consider when gathering an assessment. Next slide. Other important considerations include whether or not the adult has been provided appropriate accommodations for their specific disability. Some examples of this are assistive technology. Do they need an interpreter? Do they get distracted easily and need a room free of distractions? It's also important to consider if the adult has been given the opportunity to practice decision making. So as George touched on, and as we touched on a little bit in the last slide, decision making is a learned skill, and we all make mistakes. We all should be given the right to learn from our mistakes, regardless of whether we are typically developing or have a disability. Next slide. It's also important to consider if the professional has had adequate opportunities to determine decision-making capacity. So as we all know, with interactions with clients, it can be different every time. It is not appropriate to identify whether you think an individual can make decisions or not based on one interaction. And I think it's also important to acknowledge that without a good rapport and without established trust, you can't really gather an appropriate assessment about whether this individual can make decisions or not. Next slide. And so before giving a recommendation, I think it's important to open communication with the individual about barriers that they may experience regarding decision making. It's important to address challenges. So as we talked about earlier, has someone established the role of as the decision maker? And do you need to talk about that with the adult and possibly with the caregiver who has established that role? I think it's important to educate about decision making as a learned skill, the idea that everyone has the right to learn how to make decisions, obviously to which they are capable, and everyone has the right to learn from their mistakes, from decisions they've made. It's also, so that's that. Next slide. So our friend Jen wants us to remember to listen to our patients, hear what their goals are, and work a plan with them to best incorporate reachable goals with the resources that they have available to them. And we kind of talked about that. I feel like that wraps up really nicely when discussing gathering a good assessment and communicating about barriers and other things to solve problems with patients. Next slide. So now that you've given the adults all of the information, they decide they want to go through with supported decision making. So now we're going to talk about next steps. Next slide. So We mentioned earlier supported decision-making agreements, which are necessary to implement supported decision-making in practice. A supported decision-making agreement is a legal paperwork that's necessary for supported decision-making, and it is available online. On the next slide, I will give you the resources to access the legal paperwork, the supported decision-making agreement. It is important to remember that the agreement itself and the team that creates the agreement is led by the individual with the disability, because they are individuals and they get to decide who they want to create an agreement with as supporters, and they get to decide who sits at the table whenever they're making their agreement. They do not need a lawyer or an attorney or anything to create the agreement. The necessary components for the agreement to become legally binding include the signature of the person with the disability, and then the signature of anyone that they are going into a supported decision-making agreement with. They also need either 2 witnesses or a notary. Next slide. So here are a few resources. On the left, you'll see a screenshot of the supported decision-making agreement. Please know that I recognize the font is tiny and I don't need you to be able to read the font. I just wanted to give an example of what part of the agreement looks like. And then the blue link, you can click on that to access the supported decision-making agreement. For any of the links in the presentation, if you have trouble clicking on it and accessing it, I did put the links in the notes because we recognize that on some computers, such as Macs, not all of the embedded links work. Another good resource for a supported decision-making agreement is from the Wisconsin Board for People with Developmental Disabilities. They have a really great toolkit for families that I highly recommending to families and to adults if they're going to go through a supported decision-making, as it's very informative. The South Carolina Supported Decision-Making Project also has a couple of resources for providers. And so there's one there, and then there's one later in the presentation. Next slide. I did just want to identify this specific resource that's within the Wisconsin Board for People with Developmental Disabilities Supported Decision-Making Toolkit. And this is a supported decision-making agreement tracking form. And I think it can be really helpful to individuals as they have, if they have multiple supporters, so that they can keep track who they're in an agreement with, and they can keep track of what they have decided they want that supporter to help them with when making decisions. And they can also keep track of who they've given that agreement to so that they know where they're at. Next slide. So our friend Jen wants us to remember to repeat, repeat, repeat. Sometimes she works on the same plan with a patient for 6 months before they take the first step in a plan that they helped to create. Celebrate successes as they do happen, even if they are small. There really has to be a personal connection for the decision-making process to work well. Next slide. And so now I'm going to hand it over to George, and he's going to talk a little bit more about the legal aspects of supported decision-making agreements.
Okay, thank you, Kristen. Now, a supported decision-making agreement is designed for people to break out different sections of their life and include different people in those different pieces of their life. For example, somebody, a friend or a family member may be appropriate to help with medical decisions, medical appointments, medical decisions, even setting, prior to, going into an appointment, at the appointment, post-appointment, things like that. You may have a different supporter who you want involved in terms of working with your financial institution. And what I recognize that supported decision-making is not a silver bullet. We're going to be learning as we go, but it is now a thing. I have a friend who's with GWAR, the Greater Wisconsin Agency on Aging Resources. And after this law was passed, she was in a courtroom, and the judge actually asked if the people were who were going for guardianship for their child, their soon-to-be adult child, and the law was now in place. And so the judge from the bench asked if the parties had considered supported decision-making, which could be a less restrictive approach to supporting this person than a guardianship would be. And it turned out at that time they had not. So there was this thing, this document, this law that can be pointed to, which when we started did not exist. And when, as an example, when we interacted with a financial institution, they pushed back. They wouldn't let my son open an account without having a power of attorney form on file. Now, I know they didn't have to have that, but in order to open the account, that's what they required. And to this day, there are statements that come to the house that have my name on it, followed by the abbreviation GDN. And that doesn't stand for Great Dad Now. It stands for guardian. And I'm not his guardian, but this big financial institution in their system has a form or a statement that comes out, and that's what's on the top of the statement. So the idea is when you have this form, you work with somebody ahead of time so that you can get a better understanding of their wishes, where they need the help. So there's work that's done ahead of time before you go into the appointment. That's the goal, so that when you go into the appointment, then you know that these, the two people, for example, that are there, if I were to show up with my son, that in fact, we've talked about it. He signed a release. It's on file. And to Kristen's point, some of this is very similar to power of attorney for healthcare. You need people to know, you want to keep a record of it. And then you also have a sense of the boundaries of what it is, because that's also included in the document. If you don't check something, you're not there to help them in an area that's checked either no or not checked at all. We try to default in ways that really make it intentional about what people were looking for help on. And also, some people may not consider it a big deal, but when you work in the disability community, getting records can be a real challenge. I mean, if you've got a couple of different healthcare providers and you've got to collect stuff because you're going to go to a specialty appointment, a person who can't drive, like for example, my son, he can't drive. So to get records, we have releases, but I'm able to go to various clinics to be able to get copies of those records. Sometimes, an example, maybe of an x-ray. So it allows the person to have more control and autonomy in their life as they prepare for an appointment and then when they show up for an appointment. I've had examples in my own practice where if somebody shows up with a supporter, I have to make a real effort. Hopefully I get better at it, and I have gotten better at it, of looking at the person with a disability as opposed to their supporter. A number of years ago, I had an individual come into my office who was in a power chair. They had cerebral palsy. It impacted their ability to speak. It had nothing to do with their mental processing. But their friend Mike was with them. Bob was there in the power chair, and they were looking for a way to be able to interact with systems, banks, healthcare providers, and they didn't want a power of attorney. Mike did not want to transfer decision-making over to his friend Bob, and guess what? Bob didn't want it either. He just wanted to be able to go there, but the frustration that Mike demonstrated when he would go to appointments, and inevitably, as he slowly tried to communicate his wishes, people would gravitate to the interpreter. They gravitate to make the assumption that, oh, the person here is the caregiver. They know more. We can move this thing along. And so then Mike would actually be physically, visually, in a sense, cut out of conversations because the the discussion would then switch to Bob, for example. And at the time, we didn't have the supported decision-making law in place. And I told him there really wasn't a whole lot that he could do short of a power of attorney, and that was not an option for him. So it's important when someone comes into the agreement to realize what that person's role is, and it's to help them, because maybe when somebody speaks that is slower, and they may rely on that person to help interpret what their language is, not what their decision is, but in terms of their language. And also it might be that having familiarity with an individual, that I could, for my son, take information that maybe is more complex or communicated in acronyms and the like, and translate it into an appropriate form that he will understand and that he can then work to make decisions on. And the other thing about these agreements is that they can change over time. You can substitute people, and none of it requires the court to be involved. And you may have to have some tracking, but I think that's appropriate even if you're a fully functioning adult and you're an elderly person and you have maybe one of your sons or daughters as your financial power of attorney. You're going to want to keep track of what banks and financial institutions have those documents. So I think it's really important. I mean, it was interesting. A personal story, when my son was going to work, he was involved in a car accident with the transportation provider. He was fine, but he got a little shooken up. And so we decided to go to the emergency room it was late on a Saturday. And when we walked in, it was our regular hospital, so they have their records. And I wasn't allowed in the room to start with because he's his own person. And so they checked him out, asked him some questions. I have to trust that he's going to be okay in there. He has to learn to be able to advocate and talk about, how he's feeling. But after they did the initial assessment, asked him the question, did they want me to be in the room? He assented to that. And so then I went in and we proceeded with the appointment. But it demonstrated to him as an individual under an emergency circumstance, hey, this is your life. This is affecting you. You need to interact with this system, and also the system needs to recognize that he is an individual who can participate and be supported in making decisions about healthcare. Do I say next slide? And that's the thing about guardianship is you're presumed, you are determined, not even presumed, you are determined to be incompetent. And there can be a whole host of biases that come with that. We were very conscious when we developed the law that if you use supported decision making, it cannot be used as evidence that you have issues, that you may be incompetent, that people could bring this out and use it in a guardianship proceedings and say, oh, they use supported decision making. I have elder practice. We're going to see more and more people with age-related disabilities, and things are going to come at, a mom or dad fast and furious in an appointment. They may be hard of hearing. They may want a loved one in the room with them. And if you have a supported decision-making document, you can move that. You can have permission to be in the room. And we provide liability protection in Chapter 52 under Subchapter 3. So we recognize that if you get one of these, you can rely on it, and it will protect the healthcare provider. So that talks a little bit about liability protections, because we recognize that somebody comes in and decisions are made and you relied on that. It does not absolve, though, anybody from a mandatory reporting. If you suspect abuse, you still have to go forward and report that in good conscience. It's not a complete shield from any kind of liability in that regard. Okay.
All right, thank you so much, George. So on the slide prior to this one, there is a link for, we are all mandated reporters, just for the Wisconsin Adults at Risk Helpline. So if you have any concerns, that you can go there as a resource. And then if they're an elder adult, there's a specific helpline and it's on the right. Next slide. So now we're going to take another poll. And I'm just wondering if you can identify specific adults for which supported decision-making should be recommended. Okay, so we are at 31 out of 46, and everyone has said yes. So I think that we can stop the poll, and that is great to hear. And I think that really does just speak to, like we talked about earlier, how the status quo is not always appropriate. And in order to get support decision-making into practice, it really is our duty to educate patients and to give them all the options and have these important discussions with them, even when time can be a barrier. Next slide. I did want to put in a plug for the Center for Dignity in Healthcare for People with Disabilities. They were awarded a grant last October from the Administration for Community Living, and the center is based in the University of Wisconsin Center for Excellence in Developmental Disabilities in partnership with Cincinnati Children's and the University of Cincinnati. And they are leading 8 national partners to implement this project. And the goal is to educate health professionals about civil rights and support needs of Americans with disabilities. So even though they're still trying to get up and running, they could be a very good resource for us in the future. And I did include a couple of links if you're interested in the press release later on in the presentation. Next slide. So to wrap it up, guardianship is our status quo recommendation in many systems, including healthcare. And we established during this presentation that many of us have encountered patients who had guardians, even though it wasn't the best option for them. So to promote autonomy of individuals with disabilities, we must challenge the status quo and integrate tools into practice with the least possible restriction on individuals with disabilities. Supported decision-making not only promotes independence and autonomy, but it also contributes to successful transition into adulthood, psychological well-being, self-determination, and confidence for adults with disabilities. Next slide. Jen wants us to remember, don't give up, one step at a time, and realistically, this is what you have been doing on some level all along. We want our patients to have the information to make the right decision with medical guidance, be a part of the team rather than the boss. Next slide. And so from this point on, I have included a few slides with resources. Everything we talked about today was specific to Wisconsin. If you're interested in supported decision-making and the laws in other states, the National Resource Center for Supported Decision-Making is a really good resource. Next slide. Here are a few specific Wisconsin resources if you're interested. Like George mentioned earlier, the Greater Wisconsin Agency on Aging resource is a good place to search information, and also the Wisconsin Board for People with Developmental Disabilities. Next slide. And then here are those resources from the South Carolina Supported Decision-Making Project that I mentioned earlier. And then some just information specific to self-determination. And then the first one is for people with disabilities and aging adults, and the second one is actually for children and youth with disabilities. Next slide. And then our last slide for resources, these are the resources that I was talking about earlier. For whatever reason, I linked them to the logo and not to the words, as you can see. And then the links are also in the notes. Next slide. So if you would like to get in contact, we are asking everyone to contact Julie Hajewski or Beth Moss, as she mentioned earlier, and her contact information is here, and she can direct you to the right person. Next slide. So thank you so much for participating in this presentation. It's been a pleasure. Like I said, I wish it was in person, but special thank yous to Julie and Beth and Anne and Tim and George for making this possible. Next slide. And this is just a list of references if you're interested.
So Kristen, before we go on, we do have a question in the chat box. Does supported decision-making have to be used by itself, or can it be used in conjunction with the power of attorney or limited guardianship?
Yes, it can be used to augment both of those options.
Thank you. And we will be sending the PowerPoint. Beth, do you know if we'll be sending it out to attendees or just posting it on the website?
Well, I believe we'll post it on the website. And yeah, I think it would be best probably to post it on the website under the Learning Community tab on our website. And I'll put the website address on here as well. Everybody can see that. Does anyone have any other questions for Kristen or George? All right, while you're thinking, I do have a message that I put in the chat box several times already, but I would ask that everyone who is attending to put your name and organization in the chat box. And if you're not able to connect by computer, that you email your name and organization to me at guthriemoss@wisc.edu. And also that you fill in our evaluation. The link is in the chat box as well.
We do have a question in the chat box. Can a guardianship be rescinded and replaced by supported decision-making agreement? Oh, the getting rid of guardianship. Go ahead, guys.
So I think George has probably had a lot of experience with this. What I do know is that it's really hard to get a guardianship rescinded once it's in place. The GUAR resource, it does have information to talk to a guardianship attorney helpline. So if you want to rescind a guardianship, you can go there as a resource. George, do you have any other insight into that?
Yeah, that was one of, excuse me, that was one of the other big drivers in moving for this law and wanting to get to the Department of Public Education and get to parents sooner rather than later about guardianship. Because, I mean, we've broken our look out at people who are already under guardianship, and we're trying to figure out ways to address that. But the on-ramp to guardianship is basically through the school system. I mean, the research has shown that. And if you think about it, if you have been with evidence determined by a court of law to be incompetent, to undo guardianship is a pretty significant undertaking. I have done, I've helped modify a guardianship, but I have not undone one. I've been in the courtroom when a couple have been undone, but it's been a rather intensive process, a very deliberate effort by the parents to develop their loved one's experience to demonstrate and have documented evidence to say that they now can have the guardianship removed so that the person can go on with their life, and then they can use supporters and supported decision making. But it is extremely difficult to undo a guardianship, which is why we're looking at limiting the creation of them to start and at the early stages at 17 and a half, 18, because then like for my son, he has 7 more years or 5 more years as his brain is developing to learn more skills. And as I said, I still don't know, I'm candidly, whether or not looking at it, you know, more down the road, whether a limited guardianship might be appropriate, or then we could pick certain areas and say, yeah, this is really where we need to substitute judgment. He has a complex seizure disorder. He takes thousands of milligrams of medication a day to control his seizures. I have concerns going forward about whether or not that's going to affect his major organs because of the toxicity of the medication. So that might be an area, I don't know, but it's really hard. So that's why we want people to think long and hard before they initiate one. And some of our next work is to figure out if there are ways to help people either roll back guardianships, or get resources to people to really consider how to remove a guardianship. But you've been declared incompetent, and you have to then demonstrate to the court with evidence that you are now competent.
We have another question that's come in. I'm wondering if anyone with the supported decision-making agreement has gotten pushback or hesitation for things like elective surgery or consent to psychotropic medications. These are sticky spots that this person has heard of in other states. I'm just wondering if anybody has any experience of that in Wisconsin.
So Amy, that's a great question. I have heard from some people who have gotten pushback of even just having a supporter in the room and using supported decision-making face-to-face with a provider or with a healthcare professional. So I can only imagine that there has been pushback when giving informed consent or consenting to medications that are complicated, like psychotropic medications. I guess I personally don't have experience with that, but I would imagine that that's a problem that we're going to face moving forward. And that's part of the reason that systemic change and us being advocates and implementing supported decision making and giving recommendations in practice is going to be so important.
Okay, thank you very much, Kristen and George. I think we're going to wrap up now and honor everyone's time. The presentation was extremely informative, and the information you provided is so important for health professionals to be able to assist their patients in transition to become more independent. The evaluation link, again, is in the chat box. Our next learning community call is Thursday, September 17th, and we hope you will join us. The title is Healthcare Transition Stories about Challenges Faced by Generation Z. During this call, a parent-youth team from 3 families will tell their stories of transition and how they are coping with the move from pediatric to adult healthcare. More details on that call will be posted on the Learning Community page of the Youth Health Transition website. And that website is in the chat box. And we have another link to the evaluation. Thank you, Lynn. Thank you very much for your participation. Thank you to our presenters, and everyone have a great day. This concludes our presentation.